Hi everyone, today I'm going to be talking about the competence to refuse an insanity defense, which is in section 706 of Melton. This topic deals with a specific type of decisional competence and focuses on situations where a defendant may have been mentally ill at the time of the offense, but does not want to raise an insanity defense, even when their attorney or the court believe that the defense would likely to succeed. The main legal issue here is whether a defendant who is otherwise competent can refuse an insanity defense or other mental state defenses. This situation usually comes up when there is a strong evidence suggesting that defendant was insane at the time of the offense, but the defendant still wants to proceed without using the defense. The question then becomes whether the court or defense attorney has the authority or possibly even the obligation to raise the defense anyway. This issue is important because insanity defenses exist to prevent the punishment of individuals who are not morally responsible for their actions. At the same time, forcing a defense on someone can seriously undermine personal autonomy. The criminal justice system places a lot of value on defendants' ability to make decisions about their own case. Courts are essentially trying to balance society's interest in justice with the defendant's rights to control their legal strategies, even when that strategy may seem unwise. Courts have taken two main approaches to this issue. The first approach comes from the Yolla v. United States, which allows a court to impose an insanity defense when the evidence strongly supports it. The second approach comes from the Mrad v. United States, which holds that if a defendant is competent, their decision to refuse an insanity defense should generally be respected. These two approaches reflect very different views about responsibility and autonomy. Under the Yolla approach, the focus is primarily on society's interest in maintaining the moral integrity of the criminal justice system. The reasoning is that criminal law is built on the concept of responsibility and convicting someone who was legally insane at the time of the offense. Because of this, judges following Yolla may require an insanity defense to be raised even over the defendant's objection. Today, this approach is considered a minority view, although a few jurisdictions still follow it. The Mrad approach takes a different position and places much more emphasis on the defendant autonomy. The court Mrad pointed out that competent defendants are allowed to make other major decisions, such as pleading guilty or representing themselves at trial. Based on this reasoning, the court concluded that a competent defendant should also be allowed to refuse an insanity defense. This approach is now the majority rule and reflects a broader trend towards respecting individual decision-making in criminal proceedings. Courts have also recognized that refusing an insanity defense is not necessarily irrational. Defendants may worry that an insanity could lead to a longer period of confinement in a mental hospital than they would face in prison. Others may want to avoid the stigma associated with mental illness or fear losing certain civil rights as a result of commitment. In some cases, defendants may view their actions as political or religious in nature and believe that an insanity defense would undermine that message. In jurisdiction that follows the Mrad approach, forensic evaluators focus on whether the defendant is competent to waive the insanity defense. This includes assessing whether the defendant understands what insanity defense is, what alternative exists, and the potential consequences of each option. Evaluators also examine the defendant's reasoning process, especially whether the refusal is influenced by symptoms of mental illness, such as delusions or a complete denial of mental disorder. In some cases, this evaluation may go beyond a typical competence to stand trial assessment. the Unabomber case, there was clear evidence of mental illness. Kaczynski strongly opposed using an insanity defense because he believed it would undermine his beliefs and how he wanted his actions to be understood. So, competence to refuse an insanity defense is considered a form of decisional competence. While courts were once divided, the majority view now follows Frandak, meaning competent defendants are usually allowed to refuse mental state defenses. Courts generally prioritize autonomy, even when the decision may lead to more severe legal consequences for the defendant. So my discussion question is, when a competent defendant refuses an insanity defense despite strong evidence of mental illness, should courts prioritize individual autonomy or society's interest in preventing morally undeserved punishment?